Let's come back from the break, please. We are
Madam,
back after a short break. Madam Chair and other board members. Oh, wait, I see Mr. Nykiel raising his hand. Mr. Nykiel?
yes, thank you, Madam Hearing Officer. I apologize. I would have liked to have suggested this before we went on the last break, but just considering, thinking through the implications of our exhibits not having been transferred from the old website to the new website, I'd like to suggest that potentially we excuse Mr. Nichols for the moment, and if it is possible, recall him tomorrow morning after public comment, just given the fact that our exhibits, you know, probably can't be read in very great depth in 10 minutes, and to give the board ample time to the extent they choose to review that. And would just suggest that as a potential solution to kind of be flexible here.
Alrighty, I think that's a reasonable suggestion. Madam Chair, how do you feel about that?
Thank you, Madam Hearing Officer and Mr. Nikhil. I'm looking at the other board members as well. I think, I think that's a great suggestion, given that we've had a lot of time with some of the other exhibits that were already posted, and we were able to go through those in detail and have that time to process them. I think it would only be fair that we could do that for Wild Earth Guardians as well.
Okay. Thank you. Then I do see the other board members nodding. Mr. Nichols, I am sorry for the inconvenience, but if you would join us shortly after 9 o'clock in the morning, we could set up the board member questioning for you after public comment.
That sounds great. I can make myself available, and then I presume we'll continue with rebuttal and whatnot.
Mr. Nykiel, what do you think? Rebuttal after the exhibits?
I think so.
All right. I mean, since we're recalling you anyway, Mr. Nichols, it would probably be better for the board members to follow your rebuttal. All right. Thank you very much, Mr. Nichols and Mr. Nykiel.
Thank you, Madam Officer and Madam Chair and Board.
All right. There is another person. Let me do this while I'm thinking about it. I think it was Mr. Colclasher said that his witness, Kim, is not available this afternoon, and we would be taking witness Kim in the morning as well. Mr. Colclasher?
Yes, Madam Hearing Officer, that's correct. And we did flag previously that Mr. Nichols would be unavailable this afternoon, and so if he is called to rebuttal on this topic, we'd prefer to do that tomorrow. May I also ask a follow-up question about Wild Earth Guardians witness, Mr. Nichols? I understand he's coming back tomorrow for board questions. Previously, you moved very quickly from Mr. Rose's cross-examination to the questions about their exhibits. And so my question is whether other parties would also have the opportunity for cross-examination to continue tomorrow morning.
Oh, absolutely. If I moved too quickly there, I apologize. This platform means we need to work together to stay on track. So thank you for that.
Thank you.
Yes, of course. Yes, of course. Let's see here. Mr. Rose?
Yes, IPA&M's witness Blewett is, his testimony responds to Mr. Nichols, and it would, I think, be appropriate for him to go tomorrow morning as well. After we completed Mr. Nichols' testimony, I think it would make more sense to the board members to follow that.
All right, thank you. Let me ask Ms. Katz then. Oh, well, and I guess I also need to ask Mr. Heiser about witnesses Smitherman, Meyer, and McNally, and Ms. Katz about Keene, Palmer, and Baca. Ms. Katz, I see you first.
Yes, I mean, I believe we would want to go after Mr. Nichols' testimony. That would only make sense. I just need to check. I don't think that anybody is unavailable tomorrow.
Thank you. And Mr. Heiser.
Madam Hearing Officer, I don't believe that Mr. McNally doesn't really have anything to testify to in this section. And I think Mr. Myers is now not as relevant given the department's statement about the tanks definition. And so Mr. Smitherman is with us every day. And so to the extent we needed to do something, it'd be easy for him to just quickly follow on at the end of tomorrow, before Ms. Katz, obviously.
Yeah. Thank you very much. Sounds like we have a plan. All right, Ms. Katz, then are we moving from 21 to 22?
Yes, Madam Hearing Officer. And I believe I'll call Elizabeth Bisbee Keene again on that. I don't think Mr. Palmer is involved on that one.
All right, and just be sure to mention exhibits, and Ms. Keene is still under oath.
Yes, okay, let me, so this is also going to be in NMED exhibit 32. Starting on page 3. And rebuttal, NMED rebuttal exhibit 1. I don't have the page number at the moment. Excuse me. Actually, I don't even know if this is actually in the rebuttal. So I'll just have Ms. Keene start with the slideshow and we'll cover everything. So Ms. Keene, you already adopted this testimony on the record, correct?
Correct.
Okay. So so now we're getting into the provisions of the rule. And before we actually get to the first sort of main substantive section, which is applicability at 20.2.50.111, I'm going to ask Ms. Keene to cover the overview about the equipment database, the NMED, where the data came from, and the key exhibits that we are referred to throughout the testimony of Ms. Keene and Mr. Palmer, and that's all in the NMED exhibit 32 in the page numbers that I identified. So, all right, Ms. Keene, can you please describe the department's Air Quality Bureau's equipment database, please?
Yes, and board members, you'll hear from the department and ERG witnesses about the equipment list that we have used to develop the relevant sections of Part 50. And so this will speak to the database where that information was pulled. And so I'll start there. So the Bureau utilizes an equipment database called Tempo to record and monitor and track information about regulated equipment and facilities regulated under the Air Quality Control Act and the board's regulations. And information is collected from air permits, compliance report submittals, other types of notifications, settlement requirements, emissions inventories. And the data is structured in a way, well, we capture 2 different types of data, really, one on the facility level data and one on equipment level data. And for facility level data, we are capturing the company that owns, operates, and is the billing party for that particular facility. the person designated as the main contact, estimated potential and actual emissions of facility-wide emissions, location information, applicable air regulations, the reported NAICS and SIC codes. Those are industrial classification codes that identify the type of equipment and other general information related to the facility. And on the equipment level, we track information, including equipment stack parameters, and including flow rate, height, velocity, temperature, stack diameter. Those are all inputs into the air dispersion models that we use. We track the operating hours of that equipment, the pound per hour and ton per year emission limits of all regulated air contaminants, control device, if applicable, and the efficiency of that particular control device, as well as fuel type, the heating value of the fuel, and fuel usage rates for each piece of equipment that combusts fuel. And then as well, general information such as serial numbers, manufacture and construction dates, capacity rates or throughput rates, for instance, horsepower or million BTU per hour capacities, federal air regulations and state air regulations, as well as the source classification codes, which are a lower level of code that identify that specific piece of equipment. This data.
Can you provide, sorry,
Go ahead.
Can you provide, can you discuss how that data from the Tempo database was provided to ERG for their cost and emissions reductions estimates?
Yes, the department downloaded all the equipment and facility data for the respective counties and limited those searches to only oil and gas related equipment. We provided that data to ERG. ERG used that data to develop the equipment spreadsheets used to evaluate the emissions reductions and the cost estimates of this rule. The department data provided to ERG is included in a tab in each of the equipment spreadsheets and is referred to throughout this testimony as Nmed equipment data. And the ERG spreadsheets are provided as exhibits in electronic format as Microsoft Excel files.
Thanks. And can you walk through the summary about of your testimony regarding the key exhibits that are referred to in your and Mr. Palmer's testimony?
Yes, Nmed and ERG developed and relied upon several key documents in developing the proposed rule and the supporting technical information. And these documents are referred to throughout our testimony. And the following list contains the exhibit number, name as referred to in the testimony, and then a brief description or citation information for each key document. And so the first key exhibit is the EPA Control Techniques Guideline, which is an EPA Office of Air and Radiation report that they put out to identify potential control options for non-attainment areas for the oil and natural gas industry. The second key exhibit is New Source Performance Standards, subpart Quad O, which is EPA's federal rule for new sources, and establish standards of performance for crude oil and natural gas facilities for which construction, modification, or reconstruction commenced after August 23rd, 2011, and before September 18th, 2015. And the third key exhibit is New Source Performance Standard, subpart Quad A, which was a modification of the previous NSPS and is in effect for those same types of facilities that commenced construction after September 18th, 2015. The fourth key exhibit is the Pennsylvania General Permit. This is an operating permit for natural gas compression stations, processing plants, and transmission stations. Pennsylvania General Permit 5A is Pennsylvania's general operating permit for unconventional natural gas well site operations and remote pigging stations. Colorado Regulation Number 7 is Colorado's rule that regulates emissions of NOx and VOC from the oil and gas sector for the purpose of controlling ozone. And Wyoming Permitting Guidance, which is the Wyoming Department of Environmental Quality's permitting guidance for oil and gas production facilities.
Okay, Ms. Keen, can you give a summary overview of what Section 111 of Part 50, titled Applicability, covers?
Yes. Subsection A, or rather the whole section 111, outlines the specific sources of air pollutants that are covered under Part 50. And the rule applies, as we'll soon learn, or as you know already, to crude oil and natural gas production and processing equipment, including operations that extract, collect, separate, dehydrate, store, process, transport, transmit, handle, in areas of the state specified by 20.2.50.2 and located at well sites, tank batteries, gathering and boosting sites, natural gas processing plants, and transmission compressor stations located up to the point of the local distribution company custody transfer station.
And can you give an overview of that section?
Yes, the section 111. What I just covered was covered in subsection A of section 111. This slide is referring to subsection B of that section. It requires owners and operators to calculate the potential to emit in order to determine applicability of Part 50 to any individual source. The PTE calculation must be certified by a professional engineer or an in-house engineer. Requirements of Part 50 may not be used in the PTE calculation, so it makes that clear. And then it also contains in subsection C of section 111 the specific requirements for small business facilities as defined in the part. And subsection D of section 111 lists specific types of facilities that are not subject to Part 50. And those include oil refineries, transmission pipelines, and saltwater disposal facilities.
Okay, and can you review the requirements as they stand with the comments that were received and the revisions that were made?
Yes, NMOGA and other parties requested the insertion of the word certain in the first sentence and the striking of the word and the inclusion of the word associated with. The department agreed with that revision. We substituted the word sites for stations. In subsection B, we received extensive comment on the fact that not all owners and operators have qualified professional engineers either on staff to make these decisions, or that it was inappropriate for a qualified professional engineer to certify to these calculations when they don't have knowledge of these specific types of operations. And so we revised this section to address those comments, which we believe satisfactorily addresses the concerns raised by the parties. And so the insertion of or an in-house engineer with expertise in the operation of oil and gas equipment, vapor control systems, and pressurized liquid samples identifies the type of experience that we would like an in-house engineer to have in order to certify that calculation. And the second sentence, the emission standards and requirements of this part may not be considered in the PTE calculation, was a clarification for owners and operators that that clarified that you cannot use the requirements of Part 50 to reduce your emission rate in order to determine the applicability of this rule to any specific source. And the last couple of revisions were minor clarifications, minor revisions to the term oil refinery, and then the inclusion of the saltwater disposal facilities was clarified the department's intent in terms of applicability of this part.
And can you discuss the defined terms that are associated with this section and the revisions that were made to those terms?
Yes, NMOGA and Kinder Morgan, as well as other parties, submitted a comment on these terms: gathering and boosting station, transmission compressor station, and wellheads or well site, and then requested deletion of the term natural gas compressor station. The department has revised those definitions based on those requests, and we believe that these current definitions have satisfactorily addressed the concerns raised by the parties. NMOGA, in addition, requested that the term wellhead site be redefined as a well production facility, and the department did not make that edit for the September 16th version of the rule, but the department is not opposed to redefining this term well site to be a well production facility. And that concludes this slide.
Thank you, Ms. Keene. And I believe Mr. Smitherman might have said that the wellhead site was acceptable to NMOGA, but I'll let him confirm that next time he's up. That's all I have on this section, this topic, for Ms. Keene.
All right, thank you very much, Ms. Katz and Ms. Keene. Let me pause for a moment in the event there are questions from other parties. Mr. Rose.
Yes, just a couple of questions for Ms. Keene. On your testimony about the Tempo database, you talked about it having all the equipment that the department was aware of through the various programs. Could you speak to whether well sites currently are captured in that database and to what extent?
Yes, thank you. And so well sites that emit over an applicability threshold are required to register with the department for either a notice of intent or an air permit. So those facilities that are required to register with the department are included in the database. Those facilities that are not currently regulated by the department are not present in the database.
Okay, thank you. And that would include sites with a potential emission rate of less than 10 tons per year, I think is the NOI threshold currently.
Correct.
Thank you. And with respect to your changes on who has to certify the PTE calculations, just had a question about, it looks like you're retaining the requirement that it be an engineer to certify to those calculations, either in-house or a professional engineer. Did you intend to exclude other environmental professionals, for example, who prepare and submit NSR applications to the department? It appears as though that's what the definition would preclude.
Yes, it was intended that an in-house engineer with that type of expertise certify the PTE calculation.
And what about outside professionals? For example, I know companies for the most part hire consultants to prepare their permit applications for submittal. As I read it, it would preclude, unless they had a PE on staff that would certify it, it would preclude the consultants from preparing and submitting and certifying to the PTE calculation as well, correct?
That is correct. And it doesn't necessarily have to be a professional engineer. It can be an engineer with a that is not a certified professional. And this calculation is the most critical calculation to determine applicability under this part, and we need that calculation to be certified by someone with experience in those that has the experience that's listed in the rule, and we feel that provides an additional level of review and assurance that the calculations were performed accurately and are truly representative of the potential emissions from the source.
And you would agree that currently that, for example, submittals of notices of intent or NSR permit applications, which also have fairly complicated calculations, including emission calculations, do not currently require that an engineer certify to those conditions, correct?
They do not.
Okay, thank you, Madam Hearing Officer. That's all my questions.
All right, thank you. I think I saw Mr. Heiser joining us on screen. Mr. Heiser?
Thank you, Madam Hearing Officer. Good afternoon, Ms. Keene. I was wondering if you could put your definition or the 20.2.50.111 back up on the screen for just a second. We got a nice picture of Miss Orth. If it won't go back up, we can just ask the question without it.
Here we go. Sorry about that.
No, that's
Officer.
yes, perfect for that. And the question I wanted to ask you was about subsection B. And you're talking about that the emission standards and requirements of this part may not be considered in the PTE calculations required in this section or determining of any source subject to this part. And I just wanted to clarify that if a source is subject to more or less some identical requirements under Part 50 and under another federal program like NSPS or a permit condition that would be federally enforceable, we would still be, we being industry or the source owner or operator would still be able to account for that federal standard or the permit limitation in calculating the PTE for purposes of this part.
Yes, they would.
Okay, thank you very much. Appreciate the clarification.
Thank you, Mr. Heiser. Thank you for not sharing your screen anymore, Ms. Keene, so that I can see if there are any other council or party representatives who have a question of Ms. Keene. No? All right. We turn to the board members for their questions while I'm doing that. In the event you're an attendee on this platform and you would have a question for Ms. Keene about this topic, please reach out through the chat. Madam Chair, do you have a question?
Thank you, Madam Hearing Officer. I do. I just have a couple of clarifying questions, and it goes to, I believe, I'm trying to forward that, is the language about in section, it is related to the engineer certification and the use of engineer in 20.2.50 111B. And I just wanted to know if in the definitions, and I was trying to go back and forth, is it clarified what an in-house engineer is in the definition? And I just want to be careful and mindful and cognizant that the use of engineer as a term has unique, and just in general, unique, I guess, licensing requirements in the state of New Mexico. I just want to make sure. So that's the background on my question.
Thank you, Chair Spina. Yes, the definition, there is a definition of qualified professional engineer in the regulation. That definition reads, Qualified professional engineer means an individual who is licensed by a state as a professional engineer to practice one or more disciplines of engineering and who is qualified by education, technical knowledge, and experience to make the specific technical certifications required under this part. And so that definition is in place. We do not have a separate definition for in-house engineer. The important distinction, I guess, is that an in-house engineer does not have to be a professional engineer, but should have experience with the operation of oil and gas equipment, vapor control systems, and pressurized liquid samples.
Okay, I just want to make sure that as we look at this, knowing that this is under the state of New Mexico, that there is, so in my field, I'm a small business owner and environmental and engineering firm, and I know I'm always having to really make sure that the way I categorize labor cost codes and who's doing what, even the use of engineer is very specific in the state of New Mexico. So with that, has anybody else proposed an alternative term in lieu of in-house engineer?
Yes, Member Sweeney, the Chair Sweeney, the industry parties have requested the use of an operator or outside party consultant to certify to that calculation, and the department has not accepted that proposal.
Okay. Have any of the other parties, anybody else in terms of additional language to try to revise this particular section?
Not with respect to that specific topic.
Okay, all right, thank you so much.
Okay, thank you. Vice Chair Trujillo Davis?
Yes, thank you. I do have a few questions, and I apologize. I'm kind of going off of Member Sweeney here. I was thinking along these similar lines here. So if I understand correctly, an in-house engineer doesn't have to be a certified professional engineer or certified PE. Is that correct?
That's correct.
Do they require a degree from a university or accredited university in engineering? Or does it just have to be somebody who's worked their way up through the oil field ranks?
We haven't specified the credentials, but by using the term engineer, we intended for it to be those who had obtained a degree in engineering.
Okay, so as I understand it, the PTE is the cornerstone for everything moving forward for a facility, like compliance enforcement. So it should be really, really important to make sure that those numbers are correct, and whoever's putting those numbers together are certifying them and having correct numbers, right? Because they're representing the organization. Okay. So there are other regulations that have, oh, before I get to that, a consultant can't sign off on a PTE. Is that correct?
No, that's correct.
So there are other regulations, federal regulations that allow for a consultant or an outside professional engineer to sign a document and then have it certified by a responsible party within a company. Was that considered and dismissed, or can you kind of give me some insight on that?
Sure. Yeah, and it's been my experience that that there can be misrepresentations of a source's potential to emit, and that can be done by consultants, and it's often results in ongoing compliance issues for the company, which requires enforcement action and then revisions to applications and subsequent permits to be issued based on corrected emission values. And it happens so frequently that we very much intended for this calculation to undergo the review of an engineer with a specific type of experience and affirmatively sign off that emissions representation was accurate and representative of the source's true potential to emit.
Okay. Thank you for answering those questions for me. I appreciate it.
Thank you. Member Cates?
Yeah, no questions here. Thank you.
Thank you. Member Bitzer? Member Bitzer is having connection issues. Member Duval? Member Garcia?
Yes, I do have a couple of questions for Ms. Keene.
Alright.
So just in general, I understand you got a lot of comments and feedback in the 2-year process of venting the proposed rule. And I see with your changes, you made a lot of changes based on changes that NMOGA proposed. They're most impacted by this, so I imagine they did have a lot of changes. And I appreciate that you took into account and made changes where you could. That's good to see. I'm wondering if you could tell me, if you remember, were there also some changes you made based on some of the Wild Earth Guardians request or NAVA, Center for Pacific Policy, et cetera? Do you recall if you made some changes based on some of their requests? Just in general, you don't have to give me specifics.
Where they were appropriate to make, and I don't recall any specific examples right within this section. And I don't believe we received any direct or rebuttal on this section from those parties.
Thank you very much. Appreciate that.
Thank you. Member Honker?
No questions, thanks.
All right, thank you. We did have Member Bitzer and Member Duval on the platform. If you're able to unmute yourself now, let me know. Oh, I see Member Bitzer. Do you have questions of Ms. Keene? Unfortunately, I can't hear you, but I think you're shaking your head no. All right. Member Duval.
I do not. Thank you.
All right. Thank you very much. Ms. Katz, will there be any follow-up?
Just a little bit. Ms. Keene, did the department include the in-house engineer in addition to the certified, qualified professional engineer at the request of industry based on their testimony regarding the New Mexico licensing statute that does not require an engineer employed with a company to be licensed?
Yes.
Okay, so that follows that statutory provision regarding engineers.
Yes.
Okay, thank you.
Thank you very much. If there's nothing further, we can move to the next witness, Ms. Katz, or the next topic.
There's a few other witnesses on this topic from NMOGA, IPA&M, Oxy, Kinder Morgan,
Right.
all submitted direct on the definitions that are covered in this topic, as well as the applicability section. And then there's several rebuttal witnesses. So I guess I would ask the other parties.
Yeah, okay. I just wanted to make sure Mr. Palmer isn't your next witness on this one. So I think
Yeah, sorry, he was again mistakenly included on there.
All right.
I was just copying and pasting.
Very sorry. Shall we move to Mr. Smitherman?
Yes, Madam Hearing Officer, I believe he should be on the panel list.
Up there he is. All right.
I do have slides. Can you allow me to share? Was that successful?
Yes. All right, Mr. Smitherman, can you please state your name for the record?
My name is John R. Smitherman.
Thank you. And can I remind you that you're still under oath? And did you
Certainly.
previously submit and adopt your testimony, direct and rebuttal in this
I did.
proceeding? Thank you. Have you prepared a few slides in direct and rebuttal on a number of these additional definitions and topics that we just heard?
I did.
Would you like to give a brief summary of that for the board members, please?
Certainly. Thank you very much. And Madam Chair, Vice Chair, board members, and our hearing officer, thank you for this opportunity. On applicability, as you've just heard, NMED has included a requirement that only qualified professional engineers, originally that was the only option, but in their recent red line has also allowed other qualified persons certify those calculations, and NMOGA agrees with those changes. Mostly because registered professional engineers, I think as Ms. Keene said, although highly qualified, sometimes they're highly qualified in very narrow fields, and perhaps very few of them are actually qualified in this particular field of calculating those PTE important numbers. So requiring only certified registered professional engineers was going to cause quite a bottleneck and really would not have served the purpose of the public very well, or the industry. And that's all I had on direct or rebuttal. We could go into a few comments on surrebuttal if you prefer. We could wait.
Would you go into just talk about your definition of facilities, if that's okay with Ms. Katz, so we can get through that. But let's check and make sure she's okay. The topic is, I think, covers both.
This definition of facilities.
This
Sorry.
is the gathering and boosting. Is that, did you intend that in this? If not, we'll wait until Ms. Keene goes through it.
I believe so. Liz, can you confirm that we already went through that? Or did we?
I'm sorry, I didn't hear the question.
Did Liz, did you mean to cover the other definitions like gathering and boosting and compressor station definitions in your last round of testimony?
Yes, we covered those.
Okay.
Yeah, so that's appropriate, Mr. Heiser.
Okay. I just want to make sure we weren't getting ahead of where we spoke. So, Mr. Smitherman, did NMOGA propose a couple other definitions and changes as well that you'd like to speak to?
Yes, we did. Let's start with the well production facility. And by the way, I appreciate Ms. Keene's openness to that particular term, although it seems like we're both honoring each other because we're happy, quite frankly, now with the term well site. We think that's appropriate, and there's no real reason to continue to, if you will, disagree over that. So we're happy with the term well site. We've taken in a lot of input from others, if you will, and even looking at the current definition of well site as offered by the NMED, we do find that there's an opportunity for a little more clarification there. In many cases, in fact, vast majority probably, on these well sites where most of the equipment is owned, operated, leased, controlled by a single operator, there are many times equipment on those sites that are owned and operated by others. One of the most common examples is a gas meter facility that is owned by typically a gas midstream company. It's not under the control or ownership of the operator of the facility. And so what we'd like to offer is an opportunity to clarify a well site, adding those words in blue. where it means the equipment under the operator's control, directly associated with one or more oil wells, etc., or gathering and boosting stations, if any. I think that is hopefully a clarification that will help the NMED and the regulated community.
And Mr. Smitherman, is that consistent with the multicolor chart that you previously showed to the board and the other parties?
It is.
Okay.
Those well sites are all of those things that were on that left-hand side in the gray.
Okay. And then, Mr. Smitherman, did you inadvertently jump like 5 slides into this presentation instead of starting at the top?
I don't think I did.
Okay, because this looks like your Sir rebuttal, not your direct.
Oh, it is Sir rebuttal, but in my rebuttal, oh, I think I see your point. In my, yes, there it is. Let's move up in the direct. Thank you very much, Council.
I
So
think
let's
this is
talk
where you
about
need
that.
to start.
I was. It's the same concept, though. The concept that we accept the term well site. So we'll move on from there.
Okay. Did you want to clarify a little bit about the gathering and boosting and transmission compression issues?
Yeah, let's talk about that now. This is the current proposed definition of gathering and boosting station. And just again to be clear, as you recall on that diagram I showed you, it includes facilities that deal with natural gas and compressor stations in the natural gas chain. It also deals with perhaps some facilities in the crude oil chain, this specifically what we would call a central delivery point, where crude oil is collected at a single point prior to custody transfer to the oil transmission sector. And so we've made suggestions, and the NMED has accepted those suggested changes to make sure that those facilities have a home, if you will, in these rules. And that's what we've talked about here on this slide as well.
Okay.
It's also, I want to just touch on something else, that the word stabilized is in our definition because sometimes the crude oil that makes it to a central delivery point has, in essence, become in equilibrium, if you will, and so therefore has, in essence, boiled off all of its flash volatiles, and the only thing left is the working and breathing vapors there. So just wanted to make sure that it's understood that typically you'll find stabilized crude oil at a CDP. And we'll talk on that definition for stabilized a little bit later. We've also suggested that transmission compressor stations be included. This is important because they are different than normal, if you will, or the upstream gathering and boosting stations. Typically, upstream gathering and boosting stations deal with raw, unprocessed natural gas. And that raw, unprocessed natural gas typically has much more volatile organic compounds in them than you might find in a gas transmission system. And so emissions, even fugitive emissions from a transmission compression station will have, for the same volume of gas that might be emitted, much, much lower content of ozone precursors. So it's right to have included the transmission compressor station as a separate definition, and that applicability should be considered as you look at those facilities separate from gathering and boosting stations. We also found that the natural gas compressor station was a definition that just caused really confusion. We appreciate the fact that NMED has now removed that. It did not seem to serve any purpose at all. And so we appreciate you taking that into consideration. And we're back to where I started.
Okay. Thank you, Mr. Smitherman, and apologies to the board for getting slightly out of order on the slides. Madam Hearing Officer, I don't have any additional questions for Mr. Smitherman and would tender him back for other questions from others.
Thank you very much, Mr. Heiser and Mr. Smitherman. If you would stop sharing the screen, Mr. Smitherman, I will be able to see if anyone has questions of you. Thank you for that. Council or party representatives, if you have a question, please. Let's see, I see Ms. Katz. Do you have questions?
I had just one for clarification. Mr. Smitherman, in your proposed modifications to the definition of well site, did you intend to include leased equipment as under the control of the owner or operator?
Yes, we think that leased equipment should be it is under the control of the operator and it should not be excluded.
Okay, thank you.
Thank you. Let me pause a moment in the event anyone else has a question before I turn to the board. All right, I'm going to turn to the board while I'm doing that. In the event you're an attendee on this platform and you have a question for Mr. Smitherman, please reach out in the chat. Madam Chair, do you have questions?
Thank you, Madam Hearing Officer. I just wanted to thank Mr. Smitherman and NMED for working together on the language and just also in terms of process. So I know in some of your slides, Mr. Smitherman, you said that some of your recommended changes have actually been accepted by NMED. So I was wondering, is there like a latest, since it sounds like there's been ongoing back and forth? I don't know if it's a question for you, Mr. Smitherman, or Ms. Katz.
I can try to address that. I think the latest is in Namoga's red line of September 7th, as I recall, and the latest from NMED actually is after the September 16th, I know in one section. We have actually now proposed this language, the language change on the well site. This is the first time that's been offered. So we have not gotten any kind of a conversation or response yet from NMED. We're hoping that that they give us a favorable decision on that.
And Madam Chair, I can just add that what was shown in the department slide, it should be, I believe, hopefully it's all coming from our September 16th filing, so it should be the most recent version, and that we can agree to and we also can agree to what Namoga has just put up in its slide up on those additional modifications to the well site definition.
Thank you, Ms. Katz and Mr. Smitherman. Thank you, Madam Hearing Officer. That's my only question.
All right, thank you. Vice Chair Trujillo Davis.
I do not have any questions, but I'd also like to echo Member Sweena's comments about the collaboration between NMED and Namoga and other partners. Thank you.
Thank you. Member Cates?
Exactly what Member Trujillo Davis said there. Thank you.
Thank you. Member Bitzer? His audio may have gone out. I'll move on to Member Duvall briefly. Member Duvall?
No questions. Thank you.
All right, thank you. Oh, I see you now again, Member Bitzer. Do you have questions? I believe he just indicated he does not. Member Garcia? No? And Member Honker?
No questions from me. I'll add my thanks for the collaboration to my fellow board members.
Thank you very much. Let's see. Mr. Heiser, I think I will just thank you and Mr. Smitherman. And I believe our next witness would be from IPA&M, and it would be Mr. Davis. Am I correct on that? Mr. Rose?
I believe so. I think he's on, at least he was.
There he is. All right, you're still under oath, Mr. Davis, and if you would make sure to mention any exhibits that the board would want to refer to during your testimony.
Thank you, ma'am. Thank you, Madam Hearing Officer. I think Mr. Davis's testimony today is fairly unique in that it's not occurring after 5 o'clock. So we'll try to get him on and off fairly quickly. It's Mr. Davis's testimony. His direct is IPA&M Exhibit 2, and his rebuttal testimony is IPA&M Exhibit 10. And his testimony related to Section 111, which I think is what he's going to speak about here, is a subset of that. So it should be labeled in there. I don't remember exactly which pages, but the heading should be there. And Madam Hearing Officer, I think since his testimony is limited, it might be, and it's related to the department's language about professional engineer. I'd like him to speak about the department's proposed change. It may be more efficient for him to talk about his direct and rebuttal and then surrebuttal in a sense in responding to the department's latest proposal, to not break it up. Mr. Davis, could you briefly summarize your direct and rebuttal testimony for the board?
Yes, sir. I assume you guys can hear me okay? Okay. So it's very similar to what Mr. Smitherman testified just earlier. We had concerns regarding the requirement for the certification of the PTE calculation by a qualified professional engineer. The department has made some revisions in the latest red line dated September 16th in this respect, and it addresses the majority of our concerns that we put forward, and we do appreciate that. We still have some concerns just regarding, and this kind of gets into the testimony of Ms. Keene earlier, about the limitation there with the way that the department added the in-house engineer, which was something we were advocating for. We still have some concerns that in some instances, smaller companies will use an outside consultant due to the fact that they may not have an in-house engineer. And we have found it just from surveying our members that in a lot of instances, these calculations are being done by a qualified individual that's usually designated by the company. So we do appreciate the amendments that have been made, but we still think that there's a need for additional flexibility there, you know, to allow for a qualified individual that's designated by the company.
Thank you, Mr. Davis. Just for the board's edification here, I know you explained your background before. Could you explain your background and what expertise you have in engineering expertise?
Yeah, so I'm a mechanical engineer by education, but I've worked as a petroleum engineer for the majority of my career since I graduated. I've moved into operations management. I oversee all of our regulatory compliance and field operations. We have a regulatory compliance specialist that handles the majority of our regulatory matters. And I do oversee that, but we do not have a professional engineer on staff, which again, the in-house engineer revision handles that situation. But in most cases, we rely on and designate our regulatory compliance specialist to provide certifications when we're submitting forms or permits to state agencies.
And do you believe that your regulatory specialist has the degree of expertise the department's looking for in terms of these calculations?
Yes, I mean, they're the ones that are handling this on a day-to-day basis. They're the ones that are most familiar with the calculations that go into PTE. So that's why we feel like the qualified individual designated by the company would be a more appropriate way to handle that PTE certification.
Thank you, Mr. Davis. Do you have any other comments on this section?
No, I do not.
Thank you, Mr. Davis. That concludes our testimony, Madam Hearing Officer, and we offer Mr. Davis for examination.
Thank you, Mr. Rhodes and Mr. Davis. I see Ms. Katz on the screen. Ms. Katz, do you have questions?
I just have one for Mr. Davis. Mr. Davis, did IPA&M suggest any language revisions to those applicability provisions that would address your concern about allowing a designated regulatory specialist to certify PTE calculations?
Our proposal there was to strike the certification language in the proposed regulation with the thought that would handle our concerns. We do appreciate and understand the need for that certification, and I think that's kind of based on Ms. Keene's testimony earlier. So we do recognize the need for that certification. We'd just like to see the flexibility there for a qualified individual.
Okay, but you haven't provided any specific language that would implement that?
Not at this time.
Okay, thank you.
Thank you. Are there other council or party representatives who have questions of Mr. Davis? Please appear on screen if you do. All right, I'm going to move to questions from the board. If you're an attendee on this platform with a question for Mr. Davis, please reach out in the chat. Madam Chair.
Thank you, Madam Hearing Officer. Thank you, Mr. Davis. Actually, I don't have any questions at this time. Thank you.
Thank you. Vice Chair Trujillo Davis.
I don't have any questions, and thank you for taking the time today, Mr. Davis.
Thank you. Member Cates.
Yeah, I do have a question for Mr. Davis having to do with some public input we heard yesterday or maybe today or the day before. I don't know, but someone called in and said that something like many independent operators will pay out $20,000 on a well, let's say, and the cleanup costs are 80, 60, 80, 100, whatever. And then it falls to the state or the public, wherever, to clean that up. This is off topic from your most immediate testimony and perhaps any of your testimony at all. But I just wanted to ask you whether, is there some truth to that?
So I don't know if it was on my end, but towards the beginning there, you were cutting out. But I think I understand your question being around financial surety or bonding with the industry.
Right.
So I'll speak purely from my experience, but and specifically here in New Mexico, we have a federal bond that we obtain to operate, as well as our bond through the state. And then in my experience, the way that inactive wells are handled once a well has been designated as inactive, and I believe that's 15 months of no production, we're required to put up individual financial assurance on that well that is in the amount very close to what the plugging and abandonment and reclamation costs would be. I would commend the state in their structure there. Is they keep a blanket bond type structure, but they also ensure the proper financial assurity by requiring additional bonding when a well becomes inactive, which in my opinion is when the state should be concerned and want to have that financial assurity put forward by the company. I hope that answers your question.
Yeah, it does. I just wanted a little fact check there, so I appreciate your testimony. Thank you.
Yes, sir.
Thank you. Member Bitzer?
Madam Chair, I have no questions. Thank you.
Thank you. Member Duval?
Madam Chair, no questions. Thanks.
Thank you. Member Garcia?
Questions, thank you.
Thank you. And Member Honker?
No questions.
All right, thank you very much. I think then, thank you, Mr. Rose and Mr. Davis. We'll excuse Mr. Davis for the moment. And do I understand from the spreadsheet, we're moving to Mr. Holderman, who is Oxy's witness.
Yes, Madam Hearing Officer. This is Scott Janot for Oxy USA, Inc. With me is Danny Holderman, and I will beg the hearing officer's indulgence with our technical difficulties. We've decided the easiest way for us to handle this will be when I'm done with the introduction, I'll swap spots with Mr. Holderman and everybody will be able to see him. I can assure everyone I'm quite loud enough that if there's something I need to say from the side, you will hear me.
Thank you, Mr. Dan.
So Mr. Holderman, and it's Danny Holderman, typical spelling of Danny, last name Holderman. Will be testifying in this segment on section 111 on applicability and the definition of well site in section 0.7. Mr. Holderman has 6 total exhibits. The first is Oxy USA exhibit number 1, which is his recommended changes to the regulatory program. Oxy USA exhibit 2, which was his written direct testimony. Oxy USA exhibit 3, which is his resume. And Oxy USA exhibit 4, which was a model work order prepared in connection with some testimony on section 115 that won't be relevant in this section right now. In addition, we have Oxy USA rebuttal exhibit 1, which are again recommended changes to the regulatory program. And then finally, Oxy USA rebuttal exhibit 2, which is the written rebuttal technical testimony of Mr. So I will swap out with Mr. Holderman right now, and we will get to the direct.
Thank you, Mr. Jano. Mr. Holderman, Mr. Jano has already given us your name spelling, so if you raise your right hand, do you swear or affirm to tell the truth?
I do.
Thank you. And do you need screen sharing privileges?
I do not.
All right.
Good afternoon, Mr. Holderman. Did you prepare the written direct and rebuttal testimony in Oxy USA Exhibit 2 and Oxy USA Rebuttal Exhibit 2?
Yes.
Do you have any changes to your written testimony?
No, with the exception of the revisions to my direct technical testimony that were noted.
And did you prepare?
I'm sorry, Mr. Jano. Mr. Holderman was cutting out there at the end.
Sorry, I'll answer again. I just said no. I don't have any corrections with the exception of the revisions that were noted in the revisions to my direct technical testimony that were noted in my rebuttal testimony.
And Mr. Holderman, did you prepare the proposed modifications to the regulatory program in Oxy USA Exhibit 1 and Oxy Rebuttal Exhibit 2?
Yes.
Did you have any changes to those proposed modifications?
No, but there have been multiple changes to the proposed by various parties that may warrant our updating this in the future.
Oxy USA Exhibit.
Yes.
I'm sorry, hold on. You froze again?
Sorry.
I'm not sure what's happening. Repeat your answer, please.
I just said, no, I don't have any corrections, but there have been multiple changes proposed. So it may, by various parties, so that may warrant us
The very end cut out may warrant you what?
updating, making updates in the future.
All right, thank you.
And did you prepare a copy of your resume for this proceeding as Oxy USA Exhibit 3?
Yes,
Did you prepare an example work order for this proceeding as Oxy USA Exhibit 4?
yes,
And do you adopt the entirety of all of these exhibits?
yes.
Mr. Holderman, where do you work?
Oxy USA Inc.,
How long have you worked for Oxy USA Inc.?
approximately 7 years.
How long have you worked in the oil and gas industry?
I have 17 years of experience in the industry, 6 of which have been in New Mexico.
And what do you do for Oxy?
I'm the asset director for our onshore resources and carbon management Delaware Basin business unit with Oxy USA. In the role, I'm responsible for ensuring for all oil and gas production operations and related activities carried out on the company's behalf. I'm responsible for ensuring that those operations and related activities prioritize the health and safety of our employees, contractors, and the surrounding community, that they comply with all applicable local, state, and federal laws, and that they generate value for our stakeholders.
Where did you go to school, Mr. Holderman?
I received a Bachelor of Science degree with honors in chemical engineering from Oklahoma State University in 2000.
Madam Hearing Officer, I request that all the discussed exhibits, Oxy USA Exhibits 1 through 4, and Oxy USA Rebuttal Exhibits 1 and 2 be admitted.
Thank you. My memory is that there were not objections to Oxy's exhibits. I'll pause for a moment in the event there are any objections. No, thank you. The exhibits are admitted.
Mr. Holderman, would you please summarize your testimony on sections 111 and the definition of well site in section 7 for the board?
Oxy USA appreciates the opportunity to
A little
participate.
slower, Mr. Holderman.
Oxy USA appreciates the opportunity to participate in this hearing to provide practical input on the proposed rule package based on Oxy USA's experience operating in the state. Through coordination and open dialogue with the department and other stakeholders throughout this process, including EDF and other NGOs, many of Oxy USA's initial concerns have been resolved. However, there are still elements of the rule that Oxy USA believes need to be clarified or otherwise addressed. I will discuss both Oxy USA's initial concerns and how those concerns have been addressed or remain at issue. The core of the department's proposed rule is a series of technology-based standards imposing requirements for retrofitting older equipment and installing new equipment by certain established timeframes based on the equipment's potential to emit, or PTE. Oxy USA supports additional retrofit and installation requirements to further reduce emissions, but proposes that operators have the option to determine applicability based on actual emissions as an alternative to relying solely on potential to emit. Determining applicability based on actual emissions would allow operators to more accurately target higher emitting equipment for purposes of bringing it into compliance with the rule. Oxy understands from the department's rebuttal testimony that the department believes that actual emissions are not acceptable as they may not be representative of future operations. However, Oxy does not propose to make actual emissions the sole measure. Rather, Oxy believes that it is appropriate for operators to evaluate either PTE or actual emissions to determine the more accurate measurement as applied to their operations. Additionally, as originally drafted, the proposed rule requires operators to calculate the potential to emit for each emission source and to have those calculations certified by a qualified professional engineer. While certification of potential to emit calculations is a reasonable requirement to confirm validity, requiring that a qualified professional engineer make that certification creates a significant burden in terms of time required for a professional engineer to complete and certify the calculations for each emission source. Oxy USA estimates that professional engineers would be required to conduct 6,780 hours of work, approximately 3.25 years of 8-hour workdays at a total cost of approximately $800,000. To complete this requirement for Oxy USA's approximately 645 facilities and 2,745 wells for which a potential to emit calculation would be required. allowing operators to determine applicability based on actual emissions as certified by an in-house engineer would significantly lighten that burden without sacrificing calculation quality. Allowing certification would also make the proposed rule more internally consistent. In section 115B6C, the proposed rule explicitly allows certifications to be made by a qualified professional engineer or an in-house engineer with relevant expertise. Therefore, Oxy USA suggests modifying proposed section 111 to allow certification of calculations by a qualified in-house engineer. After the submittal of my direct and rebuttal testimony, the department proposed revisions to section 11 in the rule version filed on September 16th. These edits allow an in-house engineer with appropriate expertise to make this certification. Oxy appreciates the department's consideration of the issue and supports this change. However, Oxy continues to believe that the rule should allow for consideration of actual emissions as an alternative to potential to emit. Oxy USA has also proposed definitions for satellite facilities and inactive wellhead sites, along with edits to the definition of wellhead site. Oxy believes these edits are necessary to exclude certain low-emitting sites from the LDAR inspection requirements discussed in more detail in section 116. Oxy USA has accordingly proposed definitions for satellite facilities and temporarily abandoned wellhead sites, along with an updated definition of wellhead site in section 7 that excludes injection wellhead sites and wellhead-only sites. In addition, Oxy appreciates and supports EDF, Clean Air Advocates, and NAVA's proposed edits submitted on September 19th, which are in line with the proposal in our rebuttal testimony.
At this time, Madam Hearing Officer, we present Mr. Holderman for cross-examination.
Thank you very much, Mr. Jano and Mr. Holderman. Let me pause for a moment in the event any council or party representative wants to turn on their screen to pose questions to Mr. Holderman. Not seeing any action here, Mr. Holderman. Oh, wait. Oh, no, that's the chair. Right.
It's just Mr. Heiser for NMOGA. We're just looking at the definitions that are presently in this topic. Is that correct? And not some of the other issues that were just briefly touched upon by Mr. Holderman?
That's my understanding. We are on topic 22. Ms. Katz?
Yes.
Any clarification?
Yes, I mean, I'm having a bit of trouble too, because I think I was trying to find where in this particular section some of the things that Mr. Holderman was talking about, and I believe they're related in other sections of the rule, so other topics then of the hearing. So.
Madam Hearing Officer, if I may, we made the reference in section 116 explicitly for this reason. The definition changes we propose to well site play out in section 116 and would be more properly addressed there. I think that's the point that both Ms. Katz and Mr. Heiser are probably alluding to. We just wanted to make sure that, up front, we were hardwiring that for everyone, and we can all live to fight another day on section 116, but wanted to make sure we understand that there are, in fact, cross references here that are going to matter as the board is evaluating what to do with these rules.
Thank you very much for that. With that understanding, let me ask if any council or party representatives have questions for Mr. Holderman. No? All right. I'm going to turn to the board for questions. If you're an attendee on this platform and you would have a question, please reach out through chat. Madam Chair, do you have any questions?
Thank you, Madam Hearing Officer. I don't have any questions at this time.
Thank you. Vice Chair Trujillo Davis.
Yes, I have only one question, but now that the 116 argument is coming in, I'm not sure if this is the appropriate time, so we can hold off if it's not the right time. But I was just wondering if Mr. Holderman could explain the difference between actual emissions versus PTE and his suggestion on that. I'd just like some clarification on that suggestion.
There's, I guess, a number of examples to make, so I'll try to make one. And and then can expand from there. As it states, when we submit in our permit, a throughput for the facility, we then have the flow rates that we use to then assess the potential to emit for the facility. Essentially, from that point on, there are two ways for us to reduce emissions or try to comply with the rule. The first is to make sure that we are doing the inspections and keeping our equipment in compliance and limiting leaks, et cetera. The other option is for us to modify the facility to limit the throughput and eliminate the option to emit in the beginning. The current rule doesn't allow us to lower our potential to emit if we change the process and lower the throughput through the facility to then allow us to not have to capture the cost of surveillance, even though we no longer are required to do it. So I guess an extreme example of that would be if I took a facility that had a large tank battery and I decided to bypass those tanks as a primary means, and I only use the tanks in an upset condition for when I didn't have takeaway. In that particular instance, the tanks would be empty 95, 98% of the time, and we would be out there monthly taking surveys of empty tanks based on only using a potential to emit. So there's no, I guess, I'm not saying we wouldn't do it, but there is no reward or no ability to not incur the cost of compliance without fully removing the tanks in that instance.
Okay, so if I'm understanding correctly, there's no off-ramp to refile or to adjust for changing field conditions.
Correct.
Okay, thank you for clarifying that. And I'm sure, I think we'll probably discuss that more in 116.
Probably. Thank you. Member Kate may have stepped away. Member Bitzer, I know was struggling to stay connected with us. Member Duval?
No questions. Thank you, Madam Hearing Officer.
Thank you. Member Garcia? She's saying no. Member Honker?
No questions, thank you.
All right, thank you all very much. Thank you, Mr. Jano. And, oh, there's Member Bitzer.
No questions.
Okay, Member
No
Bitzer.
questions.
Thank you. So thank you, Mr. Jano and Mr. Holderman, particularly for making your screen work with challenging circumstances. Do I understand now that we'll be moving to Kinder Morgan's witness Knowlting?
I believe that is correct.
Oh, good. I see Ms. Gutierrez. I believe I made witness Knowlting a panelist. There she is.
Yep.
Witness Knowlting, let's, if you would raise your right hand. Do you swear or affirm to tell the truth?
I do.
Okay, and if you would spell your name, please.
First name is Leslie, Leslie. Last name Knowlting, Nolting.
All right, thank you very much. Whenever, oh, and will you need screen sharing?
Yes, if you could give me screen share permissions, that would be great.
To you, Ms. Gutierrez. Okay.
That's correct. Yep. And while you're doing that, may I start with a housekeeping item? Because this is Kinder Morgan's first substantive presentation and having received no motions objecting to our exhibits, I'd like to move to admit into the record all of Kinder Morgan's exhibits 1 through 18, including attachments A through BB, as in Bravo, Bravo.
Let me pause for a moment. It's my understanding as well that Kinder Morgan's exhibits did not draw objections, but let me pause for a moment. Okay, your exhibits are admitted. Thank you.
Thank you, Madam Hearing Officer. Good afternoon, Madam Chair and members of the board. For the benefit of board members and other parties, this testimony will relate to Kinder Morgan's rebuttal testimony exhibit 11. And additionally, Ms. Knowlting's resume and qualifications are provided at exhibit 1 to Kinder Morgan's direct testimony. Thank you. Okay, Ms. Nolting, where are you employed and what is your current position?
I'm employed by Kinder Morgan Inc., where I have been an EHS specialist and am now an EHS manager focusing on air permitting and compliance.
Thank you. And can you describe what you do in your role as EHS specialist and EHS manager?
Yes, I currently assist a team of scientists and engineers in maintaining air quality compliance for Kinder Morgan's natural gas transmission network. In this role, I also review capital projects in states across the country for air permitting costs and control technology requirements. I have participated in PSD, minor NSR, Title V, and other permitting in New Mexico and other states. I also prepare annual emission inventories for facilities in multiple states, and I regularly participate in state rulemakings regarding proposed air regulations, including those in Colorado.
Thank you, Ms. Nolting. And how long have you been in your current position?
I have been in this position since 2008.
And did you submit written rebuttal technical testimony on definitions at Exhibit 11, in particular regarding definitions of gathering and boosting stations, natural gas compressor stations, and transmission compressor stations?
Yes, I did.
Do you have any changes to that testimony? And if not, do you adopt your written testimony here today?
I have no changes to my testimony, and yes, I adopt my written testimony in full.
Thank you, Ms. Nolting. Could you please summarize for the board your testimony regarding definitions as those might impact Kinder Morgan's transmission compressor stations?
Yes, I'm happy to do that. Good afternoon, Madam Hearing Officer, Madam Chair, and board members. I will be speaking with you several times throughout the course of this hearing. This presentation today will address 3 definitions, and in particular, those that are listed on this slide. And these are similar to some of the conversations that were addressed by Mr. Smitherman for NMOGA. For context, NMED has made some important changes to these definitions since the July draft. Specifically, we requested revisions to the definition of gathering and boosting station, the addition of a separate definition for transmission compressor station, and deletion of the defined term natural gas compressor station. The NMED has incorporated these changes as of the September 16th draft rule. We support these changes and thank NMED for making them and ask the board to adopt them. Before I go into these definitions, this is a diagram that you've seen before and is kind of similar to the diagram Mr. Smitherman presented. Just a little bit of background on why it's important to distinguish the transmission and storage segment from gathering and boosting. These are wholly different operations that occur at different points along the natural gas supply chain. The gathering and boosting compressor station is highlighted here in yellow. This type of boosting station is located before the natural gas processing plant, which means it moves unprocessed natural gas from the well sites. This type of gas has higher VOC content than the transmission segment. The transmission compressor station, in contrast, is located after the natural gas processing plant, which means it moves pipeline quality gas with very low VOC content, typically less than 1% VOC by weight. NMED and ERG's testimony acknowledges many of the differences between the transmission and storage segment. And based on these differences, NMED has rightly determined different treatment of these facilities is appropriate. I'd like to next take a close look at the proposed definitions as of September 16th. The revised definitions properly distinguish gathering and boosting from transmission and remove the unnecessary defined term natural gas compressor station. Here's NMED's current proposed definition of gathering and boosting. We support this definition. The key to this definition is that it rightly draws a bright line to only include those compressor stations prior to the inlet of the natural gas processing plant. Next is the definition of transmission compressor station. We agree that having a definition of transmission compressor station that is separate from gathering and boosting, and we thank the NMED for adding this definition. In our rebuttal testimony, we proposed clarifying changes to this definition, and NMED has largely implemented those proposed revisions. I will summarize those edits in the next few slides to explain why the changes are important. We thank the NMED for implementing the changes and support the current definition as set out in the September 16th draft. Finally, let's take a look at NMED's earlier proposed definition of natural gas compressor station. As you'll see with the breadth of this definition, it would capture both gathering and boosting and expressly includes transmission compressor stations. So this definition overlaps with the other two, which are more refined definitions. So NMED rightly deleted this definition from the September 16th draft. On this slide, there are a couple of sections where key places where the terms natural gas compressor station would be either imprecise or create significant compliance concerns. The examples illustrate the need to adopt NMED's recent deletion of this term throughout the proposed rules. The first point is that in each applicability section, earlier drafts referenced both gathering and boosting stations and natural gas compressor stations without a specific reference to transmission compressor stations. As noted in the prior slide, the earlier definition of natural gas compressor stations covered both the gathering and boosting and the transmission stations. And if gathering and boosting stations are already expressly listed, the use of the term natural gas compressor station would not make sense. Where the intent is to apply a certain rule section to a transmission compressor station, the term transmission compressor station should be used, and the term natural gas compressor station should be deleted. This slide shows where the NMED made this type of correction in the engines and turbines section as an example. We thank NMED for making this change to the proposed rules. The second example is in reference to section 122 regarding pneumatics. In this section, Table 1 offers a schedule for compliance with the rules section applicable to well site, tank batteries, and gathering and boosting sites. Table 2 then sets forth a different compliance schedule, which used to be applicable to natural gas processing plants and natural gas compressor stations. As shown on this slide, NMED has now revised Table 2 to refer to transmission compressor stations instead of natural gas compressor stations. This remedies the earlier confusion that that term would have created and would have made gathering and boosting stations inadvertently subject to both Table 1 and Table 2. There were other examples in the proposed rules where the use of the term natural gas compressor station would have created confusion. NMED's recent revisions to the definitions and use of those definitions throughout the proposed rules resolves this confusion and results in a much clearer rule for operators and the department alike. Again, we thank NMED for these improvements to the proposed rules and their responsiveness to stakeholder input. With respect to the definition of transmission compressor station, again, we agree with a separate definition. In rebuttal testimony, we recommended a few changes to NMED's proposed definition, which NMED since implemented. We support the definition as revised and just want to take 1 or 2 minutes to explain why the changes are warranted. First, the reference to pipeline quality natural gas is important because it is one of the key differentiating features between gathering and boosting and transmission. Second, the reference to natural gas processing plants rather than facilities is consistent with the defined term in the proposed rules. Third, the reference to transmission through a pipeline rather than in a pipeline is more accurate description of transmission operations. Fourth, there are several different potential delivery endpoints for natural gas after it travels through the transmission system. The transmission segment delivers to the local distribution company, custody transfer station, which is an NMED defined term. It also may deliver into underground storage or to other industrial users. It is important to be clear about these potential points of delivery. In closing, we ask the board to adopt the following changes reflected in NMED's September 16th draft to remove the definition of natural gas compressor station, to replace natural gas compressor station with transmission compressor station in the relevant applicability sections, and to accept the refined definition of transmission compressor stations. As an important point, these changes will not substantively revise the scope of the rule, but are extremely important for clarity during implementation. To the extent that there are any outstanding issues following party summary of their technical testimony, we may offer a rebuttal. Thank you for your time, and I'm happy to answer any questions.
Thank you, Ms. Gutierrez and Ms. Nolte. Let me pause for a moment to allow other parties, council or party representatives to show their screen to indicate they have questions of you. No? All right, I'll turn to the board then in the event they have questions. While I'm doing that, if you're on the platform as an attendee, I'll reach out through the chat if you have a question. Madam Chair?
Thank you, Madam Hearing Officer. No, I don't have any questions. And again, want to thank Kinder Morgan and their legal counsel for working with NMED and on the detailed language. Appreciate that.
Thank you. Vice Chair Trujillo Davis.
Yes, thank you. I just have one quick question. Is your major concern that transmission will get lumped in with gathering and boosting, which is a little further upstream?
Yeah, I would say that is our concern. There's certain, this is a rule to reduce VOC emissions, and there are certain activities that or control requirements that just don't make sense for the transmission segment because you just don't get a lot of VOC reductions.
Okay, thank you for that. I may have a few more after everybody else, but thank you for answering that.
All right, thank you. Member Cates.
Glad you worked out those differences, and no questions here. Thank you.
Thank you. Member Bitzer.
Madam Chair, I have no questions. Thank you.
Thank you. Member Duvall.
Madam Hearing Officer, Member Trujillo Davis asked the question I was going to ask, so no questions. I'll wait for follow-up on that.
Thank you. Member Garcia.
No questions, thank you.
All right, and Member Honker.
No questions, thank you.
Member Vice Chair Trujillo Davis, have you any further questions?
No, not at this time. Thank you.
All right, thank you. And Ms. Gutierrez, any follow-up?
I may ask just one more question just to clarify a response to Ms. Trujillo Davis's question. Sorry, Member Trujillo Davis. So Ms. Nolting, would you agree that our primary concern is that if we are defined the same as a gathering and boosting station, we would have control obligations associated with operations in the transmission segment that would not be appropriate because our operations are different and because Kinder Morgan transports a different product?
That's correct, yes.
Thank you. I think that's all of my follow-up questions.
All right, thank you very much, Ms. Nolting and Ms. Gutierrez.
Thank you.
We are at 4:41 at this point. We do have just a few public commenters at 5. Is there any reason not to take a break until 5? Ms. Katz?
Oh, Madam Hearing Officer, we could, I believe we still have EDFs. We have a rebuttal witness from EDF and on here.
I'm
So,
not. Yeah, I'm not suggesting that we won't finish the topic or go to EDF. I was just thinking it'd be good to take a break before 5.
Yes, that's fine with me. Thanks.
All right, thank you. So let's come back at 5. Thank you.